224. That's how many recreational marijuana dispensary licenses Missouri has issued. The state constitution says no single company can own more than 10% of them. 22 stores, hard cap. So why does one Arkansas company appear to control 61 of them? 61 stores, more than a quarter of the entire Missouri market. 5 different brand names: Good Day Farm, Cod's, Greenlight, Fresh Karma, and 315 Primo. All of them, the lawsuit alleges, answering to the same headquarters in Little Rock. This week, 2 Missouri growers filed suit in Jackson County and called it what they say it really is: a cartel. I'm Patrick Nolan. This is Pat Talks Law. In 2018, when Missouri voters approved medical marijuana, the Constitution put a hard cap on consolidation. No single entity under substantially common control, ownership, or management could hold more than 5 dispensary licenses. 5, period. Then in 2022, voters approved Amendment 3, the recreational legalization measure, and the cap changed shape. 5 became 10%. The common control, ownership, or management language carried over to the new section, but the lawsuit alleges the architects of the amendment built it to be functionally toothless. Here's the company at the center of the case: Good Day Farm, headquartered in Little Rock, Arkansas, the single largest donor to the 2022 Missouri legalization campaign. And, according to the petition, a company whose own attorneys served on the advisory team that drafted the constitutional amendment voters approved. The math is straightforward: 224 dispensary licenses statewide, 10% rounds down to 22. The petition alleges Good Day Farm and its affiliates touched 61. That is not within 10%, it is within 27. The lawsuit names a structure the petition calls a vertical. Here is how the petition describes it: investors put money into a Missouri LLC. The LLC acquires dispensary licenses. The LLC signs a management services agreement with a manager, and the manager, quoting the Bonver Ventures private placement memorandum directly, makes all decisions: pricing, product selection, procurement. The manager, the petition alleges, is owned by or affiliated with Good Day Farm. The investors hold the paper. Good Day Farm holds the wheel. The Bonver memorandum was even more direct. Quote, no investor should invest in Bonver unless such investor is willing to entrust all aspects of the management of the company to the manager. Bonver lists its address as 425 West Capitol Avenue, Suite 1400, Little Rock, Arkansas. Same building, same floor as Good Day Farm Corporate, the general counsel for investor communications. Good Day Farm's general counsel, William Mullen. The subscription agreement is countersigned by Anthony Cheslack, Chief Operating Officer of Good Day Farm. The petition identifies 4 of these verticals. Each one fronts a different brand. Vertical 1, Good Day Farm, 21 dispensaries. Vertical 2, CODS, 20 dispensaries. Vertical 3, Greenlight, 10 dispensaries. Vertical 4, Fresh Karma plus 315 Primo, 10 dispensaries, 61 stores, different signs out front. The lawsuit's organizational diagram puts a single common manager behind the curtain. Here is why the structure matters. Before the verticals consolidated, the typical dispensary procurement margin in Missouri was 50%. Cultivators sold to retailers at half of suggested retail. That was the working market. Then Good Day Farm began purchasing for both Good Day Farm and Codes, 41 stores at one negotiating table. The petition cites a May 2024 email from Good Day Farm's then Director of Procurement to local Cannabis. The demand, a 60% discount. The terms, and this is the petition's emphasis, not mine, quote, fill or kill, take it as written, or lose the entire account. By the first quarter of 2025, Good Day Farm was telling investors it had achieved 60% procurement margins with 48 of 50 third-party vendors, and projected in the Q1 2025 investor presentation upwards of 70% as the cartel grew. In March 2026, the order form sent to Vibe Cannabis demanded 65%. The petition alleges Good Day Farm hosts coordinated quarterly purchasing meetings internally in Good Day Farm's own language called Kiss the Ring meetings. Outside wholesalers come and pitch. The lawsuit alleges the cartel uses those meetings to set pricing and product selection across all 61 stores at once. There is even a metric. They call it the fair trade ratio, a formula. Quote, the amount you sold to us per location divided by the amount we bought from you divided by 60. 60 stores. The petition argues that the math on its own is an admission. No single entity in Missouri can legally manage more than 22. Two more pieces of the alleged scheme. First, the border stores. Greenlight operates the only legal adult use dispensary along Interstate 49 in Noel, Missouri, about 1 mile from the Arkansas line. Arkansas has not legalized adult use. Greenlight in Noel has effectively zero in state competition. Down at Rockport on Interstate 29, near the Iowa and Nebraska borders, Greenlight operates another store with no licensed competitor inside 40 miles. Iowa is dry, Nebraska is dry. The petition alleges the cartel deliberately positioned stores at choke points where consumers from prohibition states cross the line and where local market discipline breaks down. Second, the reciprocity rule. If you are a vertically integrated wholesaler and you want shelf space in any of those 61 cartel dispensaries, the petition alleges you must agree to carry cartel product in your own dispensaries. In return, the cartel tracks this on what the lawsuit calls partner scorecards. And if you refuse the price, the petition alleges you are quietly boycotted across the network. 61 stores, one contract decision. The lawsuit is a class action filed in Jackson County. Case number 2616-CV14550. Brian Cave, Leighton Paisner, and Firestein Kulik representing the plaintiffs. The lead claim is straightforward. Missouri Antitrust Law, Section 4, 16.031, says every contract or combination in restraint of trade is unlawful. Section 4, 16.141 directs Missouri courts to construe the statute in harmony with federal antitrust precedent. The plaintiffs argue the cartel's pricing meetings, fill or kill demands, and reciprocal supply agreements are per se illegal, meaning the court does not have to weigh the economics. The agreements speak for themselves. Layered on top is a constitutional claim. Article 14. The substantially common control limit voters wrote into the state constitution itself. The remedy package the plaintiffs are asking for. Void the management services agreements. Void the supply agreements. Restore independent procurement at every dispensary. Treble damages on every dollar of below market wholesale pricing extracted since December 2022. They have already moved for a preliminary injunction and an expedited discovery schedule, an evidentiary hearing in roughly 6 months. The defense will be that the verticals are independent, that the paper ownership controls, that a private placement memorandum is just an investment disclosure, not a confession. The plaintiffs will counter with the bond ver memorandum, the Q1 2025 investor presentation, and a LinkedIn post from the Good Day Farm sales director. Quote, given our market share, we've done more to keep prices stable than crater them by not dropping prices. Former Missouri Supreme Court Judge Mike Wolf warned about exactly this in a 2022 op-ed. Quote, this was from the very start an insider's game. The next year of this case will tell us whether the Constitution voters approved means what they thought it meant. I'm Patrick Nolan. This is Pat Talks Law.